Sometimes it collapses in silence. In a federal courtroom in Manhattan, there were no cameras flashing, no political speeches, no public outrage, just a judge, a legal opinion, and one sentence: Mr. Sarcone is not lawfully serving as acting U.S. attorney. That sentence did more than stop a prosecutor. It erased subpoenas, it froze investigations, and it exposed a dangerous pattern hiding in plain sight. This story is not simply about Letitia James. It is not even only about Donald Trump. It is about what happens when executive power stretches the law, when temporary appointments become permanent tools, and when criminal investigations start to look political. Democracies don't always break dramatically. Sometimes they bend quietly, procedure by procedure, exception by exception. If you want to understand how the rule of law is tested, not in theory, but in real time, stay with me. And if this helps clarify what's at stake, share it. Because to see where this is going, we first need to understand how it began. This case raises a simple question, but it carries enormous weight. Who has the authority to prosecute, and who decides? At the center is a role most Americans never think about: the U.S. attorney, a position meant to be powerful but constrained. By law, that power has limits. A U.S. attorney must be confirmed by the Senate, or, if temporary, replaced through a clear legal process. What happened here disrupted that balance. John Sarcone continued to act as U.S. attorney after his legal authority expired. He signed subpoenas, he directed investigations, he targeted a sitting state attorney general who had previously sued Donald Trump. The administration argued this was procedural, a technical detail, a gap that could be managed. The court disagreed, because when technicalities decide who can investigate political opponents, those technicalities stop being small. They become the system itself. And to understand why this matters so much, we have to look backward at how these appointment rules were designed and why they exist in the first place. To understand this moment, we need history, not personalities, not headlines. Design. The role of a U.S. attorney was never meant to be flexible power. It was meant to be checked power. Congress built the system deliberately. Prosecutors answer to the executive branch, but they are filtered through the Senate. Confirmation is not ceremony. It is a restraint. When a U.S. attorney is temporary, the clock matters. 120 days. After that, the law offers two options. Either the Senate confirms a nominee, or the court steps in. Those limits exist for one reason: to prevent prosecutors from becoming political weapons. But over time, a workaround emerged. Acting titles, interim labels, new names for old authority. What was once an exception became a habit. What was rare became routine. And when routine power no longer needs confirmation, accountability weakens. Quietly, legally, on paper, that is the system John Sarcone stepped into. And it explains why this case is not isolated, because the real crisis begins when exceptions stop expiring. And that brings us to the first breaking point. Then the system collided with reality. In August, the subpoenas went out, not quietly, not hypothetically, formally, with the full weight of a federal grand jury. They demanded records from the New York State government. They targeted investigations led by Letitia James, investigations Donald Trump had publicly opposed. On paper, this looked routine. A prosecutor, a grand jury, a lawful request. But the foundation was already cracked. John Sarcone signed those subpoenas after his authority had expired. No Senate confirmation, no court appointment, just an acting title stretched beyond its legal limit. That detail changed everything, because when a subpoena is signed without lawful authority, it is not aggressive. It is invalid. The judge did not weigh motives. She did not speculate about intent. She focused on power and she shut it down. The subpoenas were quashed, the investigations were frozen, and the message was unmistakable. Process is not paperwork. It is protection. If this moment surprised you, pause here, because it shouldn't have. This was not the end of the story. It was the first warning, and the deeper mechanism behind it was already operating beneath the surface. What mattered most was not the subpoena. It was the structure behind it. The Trump administration did not invent this approach, but it normalized it. When Senate confirmation stalled, the workaround appeared. Keep prosecutors in acting roles, rename positions, shift titles, maintain control. On paper, nothing dramatic changed. In practice, everything did. An acting prosecutor answers upward, not outward, not to senators, not to judges, but to the administration that keeps extending the role. That is the hidden mechanism. Power without confirmation, authority without accountability, law enforcement without distance from politics. And once that mechanism exists, it does not stay contained. It spreads. New York was not alone. Other districts followed the same pattern. Different names, same logic. The administration insisted this was lawful. Courts repeatedly disagreed because the law is clear about one thing. Temporary power must remain temporary. When it doesn't, the justice system stops being independent. Not loudly, but structurally. This is why the judge's ruling mattered. She was not blocking an investigation. She was defending a boundary. And when boundaries are defended, power pushes back. That pushback would soon surface again in a second, sharper crisis. The second rupture came from a different state, but the pattern was identical. In Virginia, federal prosecutors brought criminal charges against Letitia James. Not in New York, not where the earlier fight unfolded, but hundreds of miles away. The accusation was narrow. A mortgage application, a loan, a technical claim of fraud. But the structure was familiar. The prosecutor who secured the indictment was also an interim appointee, not confirmed by the Senate, installed through the same workaround. This time, the court moved quickly. The judge did not debate guilt or innocence. The case never reached that point. Instead, the court examined authority and found it missing. The indictment collapsed, not because the facts were tested, but because the prosecutor lacked lawful standing. The case was dismissed, and when prosecutors tried again, they failed. 2 states, 2 investigations, 2 collapses, different details, same flaw. At this point, the issue was no longer accidental. It was systemic. Courts were not reacting to politics. They were reacting to structure. And the structure kept producing the same result. Because when power bypasses confirmation, it also bypasses legitimacy. And that brings us to the people most affected by this conflict. Not politicians, not judges, but you. For most people, this feels distant, procedural, legal. But it isn't. Because when institutions bend, the cost doesn't stay at the top. It travels downward. You feel it when trust erodes. When the justice system starts to look selective, when who you are matters more than what the law says. If prosecutors can be installed without confirmation, then prosecution becomes permission-based, not principle-based. Today, it is a political figure you don't like. Tomorrow, it may be someone you voted for, or someone you never heard of. The rule of law only works when it works for everyone, even for people in power, especially for people in power. When courts have to repeatedly step in, that is not strength, that is strain. You don't need to follow every case to understand this. You just need to ask one question. Would you trust a system where prosecutors answer to loyalty, not law? If this matters to you, pause, reflect, and share this with someone who still believes institutions protect themselves automatically. They don't. They only survive when people notice, before it's too late. Because what happens next doesn't stop at state lines. And that takes us beyond America. What happened in New York and Virginia did not stay local. It never does. Because when the United States tests the limits of its own institutions, the world is watching. America does not just enforce laws at home. It exports norms. Independent prosecutors, checks on executive power, credible courts, these are not abstract ideals. They are the foundation of alliances, trade, and trust. When courts repeatedly rule that prosecutors lack lawful authority, that signal travels outward. Authoritarian governments notice. They point and say, even the United States bends the rules when it's convenient. Emerging democracies notice too. And they hesitate, because if confirmation and independence can be bypassed in Washington, why should restraints matter elsewhere? This is how institutional erosion spreads, not by force, by precedent. One workaround becomes a reference. One exception becomes an argument. And over time, the idea that law stands above power starts to feel negotiable. That is the real global cost. Not one investigation, not one political feud, but a slow weakening of the democratic standard America once set and enforced. And now the question is unavoidable. Where does this trajectory lead? There are only a few possible paths forward. When systems are under strain, the future rarely moves in a straight line. It branches from this moment. Three paths are visible. The first is restraint. Courts continue to enforce boundaries. Temporary appointments remain temporary. Confirmation regains its weight. In this scenario, the damage stops spreading. Not because power disappears, but because it is contained. Institutions bend, then correct. The second path is normalization. Nothing breaks outright. Workarounds remain. Courts intervene occasionally. People adapt to the friction. Controversy becomes background noise. And accountability weakens slowly, almost invisibly. Democracy still functions, but with less trust, less credibility, less moral authority. The third path is escalation. Acting roles become standard. Confirmation becomes optional. Prosecution becomes a tool of timing and loyalty. Courts are overwhelmed. Rulings are ignored or delayed. And legitimacy drains out of the system. At that point, the law still exists, but it no longer restrains power. History tells us this much. Democracies rarely collapse in a single moment. They decay through choices that seem reasonable at the time. And that leaves one final question. What do we do with what we now see? Because awareness alone is never the end of the story. This ruling did not make headlines for long. And that may be the most revealing part, because the most important battles over democracy rarely announce themselves. They arrive as legal opinions, as procedural disputes, as arguments over who is allowed to sign a piece of paper. But those details decide everything. A justice system is not defined by the cases it wins. It is defined by the limits it refuses to cross. In this story, the courts drew a line, not in defense of a person, but in defense of a process. And that distinction matters, because once prosecutors are allowed to operate without lawful authority, every investigation becomes suspect. Every verdict becomes fragile. You don't need to agree with Letitia James. You don't need to oppose Donald Trump. You only need to decide whether power should ever stand above the rules meant to restrain it. If this analysis helped you see the system more clearly, share it. Talk about it. Question it. And if you want to continue this conversation about where institutions are holding and where they are quietly giving way, stay with me. Because the next story will ask the same question, just in a different form.